Fundamental Principles of Criminal Law. Woolmington was a 21-year-old farm laborer. 3 months after his marriage to a 17-year-old girl named Violet, she left him and went to live with her mother. Woolmington stole a double-barreled shotgun and cartridges from his employer, sawed off the barrel, throwing it into a brook, and then bicycled over to his mother-in-law's house where he shot and killed Violet. He was arrested and charged with willful murder of his wife. Woolmington claimed he did not intend to kill, but actually wanted to win her back. He claimed that he planned to scare her by threatening to kill himself if she did not come back. While questioning her about returning, he attempted to show her the gun that he was to use to kill himself. By accident, the gun went off, shooting Violet in the heart. The trial judge ruled that the case was so strong against Woolmington that the burden of proof was on him to show that the shooting was accidental. At trial, the jury deliberated for 69 minutes. Woolmington was convicted and sentenced to death. On appeal to the Court of Criminal Appeal, Woolmington argued that the trial judge misdirected the jury. The appeal judge discounted the argument using the common law precedent as stated in Foster's Crown Law 1762, which stated, "In every charge of murder, the fact of killing being first proved, all the circumstances of accident, necessity, or infirmity are to be satisfactorily proved by the prisoner, unless they arise out of the evidence produced against him. For the law presumed the fact to have been found in malice unless the contrary appear." The issue brought to the House of Lords was whether the statement of law in Foster's Crown Law was correct when it said that if a death occurred, it is presumed to be murder, unless proved otherwise. In articulating the ruling, Lord Sankey made his famous golden thread speech. Throughout the web of the English criminal law, one golden thread is always to be seen, that is, the duty of the prosecution to prove the prisoner's guilt, subject to the defense of insanity and subject also to any statutory exception. If at the end of and on the whole of the case, there is a reasonable doubt created by the evidence given by either the prosecution or the prisoner, the prosecution has not made out the case, and the prisoner is entitled to an acquittal. No matter what the charge or where the trial, the principle that the prosecution must prove the guilt of the prisoner is part of the common law of England, and no attempt to whittle it down can be entertained. The conviction was overturned, and Woolmington was acquitted. He was released 3 days before his scheduled execution date. This case gives us the fundamental principles of criminal law. Number 1, a key principle running throughout the criminal law is that the defendant is innocent until proven guilty. Number 2, another key principle in English criminal law is that the prosecution, in most cases the Crown Prosecution Services, bears the burden of proof. It is often referred to as the golden thread running through the criminal law. Number 3, the standard of proof in criminal prosecution is beyond a reasonable doubt. In practice, the burden and standard of proof operates in the following way. If A poisoned B and B dies, the prosecution must prove beyond a reasonable doubt that A killed B. What happens if the prosecution succeeds in doing that? The jury should convict A. If the jury are sure that A did not kill B, then it is plain and simple that they should acquit A. Now, what if jury is not sure either way whether or not A killed B? What should happen then? In this case, jury should acquit A because prosecution did not prove beyond reasonable doubt that A killed B. Remember, the prosecution bears the burden of proving the defendant's guilt. It also bears the burden of disproving any defense that the accused may raise, other than in some circumstances where the burden is reversed, such as in the case of insanity as a defense or diminished responsibility. In the event that the accused raises one of these defenses, the standard of proof changes from beyond a reasonable doubt to on the balance of probabilities.